Record. Okay, so this is about a basic introductory lecture to the concept of property, primarily in context of commercial law. उसके अंदर हमारे पास ये रॉय गूड का एक आर्टिकल है 2023 का. इट्स वेरी कंसाइज आर्टिकल which talks about what is property, and his basic conclusion of his thesis is that for forgetting the complex debates and conceptions of property, उस पर बहुत ज़्यादा there is a lot of work on that from different aspects. He defines property as subject to statute. Property is anything of commercial value that can be realized. Now the core idea regarding this is that the core idea underlying the concept of property is that first we have to understand that property here encompasses both the real property, which is meant by land, as well as goods or other forms of properties that is not land. And in both, especially in relation to land, it is very clear, we have a clear conception developed after centuries that there is no absolute title, there is no absolute ownership. In fact, English property law, the land law, does not rely on the concept of ownership. It relies on the concept of title and interest, estates and interest. So, but this point is, what Roy argues is that this is lost when chattels are discussed. So the concept of estate, and another thing about property law is that the concept of estate was developed over centuries, and interest in the land when property was to be transferred in some way, when property was to change hands or change hand, and somebody said there were competing disputes regarding the title to property, or whose interest was involved and the extent of interest, and then courts had to deal with that when that concrete specific situation arose. So over the centuries, they developed piecemeal. The law was developed. It was not developed through a single code, which was then interpreted and applied by the courts. But in fact, situations came up and then courts applied that. And the transfers, various situations between one landlord to another, between landlord, one person having estate to her legal heirs, or interest, involving interest, that led to the formulation of the nature and extent of title and interest. So ownership can be considered as a bundle of rights that depends on the context. And as we discussed, it's a matter that becomes very important when a transfer or somebody claiming a certain interest or title to a property arises. So defining property, the Roy Goode's thesis is that property is anything of realizable, something that can be transferred or sold, or any interest can be created that gives value to one person holding the property. Property is anything realizable of realizable commercial value subject to statute, unless statute prevents you from making a commercial gain. And property issues arise in transfer of rights, security interest, especially in cases of insolvency. And I'm talking about in the context of commercial law where goods are involved, tangible, intangible goods. Because when somebody is enjoying certain goods, assets, there are certain assets on his estate or in his bank account or on the balance sheet of his trading business or company, and one day that entity goes into insolvency, then the question arises whether those goods belong to him or her or to a third party, whether he is holding those goods on trust for somebody else. And we have seen this in trust law. There are many issues we have seen where the question arose was whether certain bottles kept in the warehouse of a business were that belong to that business, belong to somebody on trust, whether it belonged to secure creditors, or whether the claim to that property was merely of an unsecured interest, as we saw in the case of real London wine. We see the same thing arising in the case of Hunter versus Moss in Re Howard Securities, where intangible goods were involved, the shares. So, property, the whole concept of property, whether it's goods or land, these conceptions were not developed by somebody, a king or lawmakers sitting together and deciding, this is what property is going to be. It evolved, it continues to evolve actually. And there are new forms of, and we see by the end of the lecture that there are many amazing, interesting examples of property that we traditionally would not associate that this kind of thing can be property. And non-valuable items cannot be property. Now, the criteria for property was the four aspects of four qualities of property. For something to be identified as property, that was defined by Lord Wilberforce in the case of National Provincial Bank versus Ainsworth in 1965. And this criteria more or less continues to be used by lawmakers, by academics, by judges whenever they deal with a new kind of claim that this thing is property and this thing is not. In this context, Lord Wilberforce, the Ainsworth case was about the core issue was whether a deserted wife's equity in matrimonial home was property and registrable under Section 70, subsection 1, subsection G of the Land Registration Act 1925 as an overriding interest. Whatever the implications of that, we're not concerned with that. The four criteria he gave, he said, and these are listed here, he said, before a right of an interest can be admitted into the category of property or of a right affecting property, so we're not talking about title, we're talking about interest, it must be number one, definable, number two, identifiable by third parties, number three, capable in its own nature of assumption by third parties, that third parties can appropriate something. As we see in the case of theft, every case of theft we have read, it assumes that there is an appropriation and there is something called property, and have some degree of permanence or stability. Because as we know, there are many goods that are perishable, they're non-perishable, they're goods whose value can be $1,000 and the next moment may be zero. So, but there must be some permanence or stability. It does not need to be as permanent as land is. So this is the fourfold criteria that you have to keep in mind. It's very exhaustive rubric that we'll see is able to accommodate new forms of property as well. Now, the classification of property in the context of English commercial law. There are two main. Right now, the law only identifies two main categories, and now there is also a discussion that there should be third category as well, which we'll discuss later. Number one, choses in possession, tangible goods. This is how commercial law evolved over the centuries. When people have been trading in goods for centuries. And second, choses in action, intangible rights enforceable by action. These also have been around for centuries. Now, the thing about property is that it is generally, we equate property with a thing or an asset, but not a relationship. Although importance of many property depends on your relationship with it, or your property's relationship with someone. And another thing is that asset transfer is an interest transfer in an asset that is exercisable against a person or all third parties. So every asset, we think of it as containing an interest that can be transferred to somebody else, or against, or it gives you an interest that you can enforce against third parties or everyone else. Now this is all abstract right now. We'll over time we'll also look at concrete examples. So these two properties, tangible and intangible. The difference, the main difference in this regard is that in terms of tangible goods, its real property or personal property, uh, such as goods and documents of title, these you can enforce against that property. If somebody has taken your asset, you can directly go and trace your asset, trace your title or interest to that item. But in the case of choses in action, these can only be enforceable by action by some legal claim. You have to bring that action, and it also now something against which you cannot bring any action. It cannot be chosen in action. And how this thing works, how chooses in action, what are the examples? Now again, it has two different categories, and this will make it more concrete and understandable. Number one is documentary intangibles. It's a kind of a choices in action. These are intangibles that are embedded rights, embedded in documents that can be transferred, that are transferred by delivery or endorsement. Without assignment, uh, these are rights that are embedded in documents without transferred, without assignment, by delivery of document or endorsements. That means that without even delivery, you have, it gives you certain rights that you can enforce against anyone. Now, what are the examples? Firstly, document of title. This denotes a document of title to goods. There are three categories of documents of title. Number one is document of title to money, a document of title to negotiable securities such as bonds, promissory notes, bill of exchange, and document of titles to goods. Let's focus on this. What are the examples of documents of title to goods? Let's start with that. This is what commercial law, international trade law, and carriage of goods law is dealing with. This involves bill of lading. This involves warehouse warrants and other categories. Now, bill of lading is a document of title to goods. It is highly important in shipping. Once you have a bill of lading that says that this ship is going to set journey from UK to Pakistan, and these goods are placed on that ship, you have title to those goods. Now you can sell that bill of lading. It is of realizable commercial value. You can transfer it to somebody. What is the example of document of title to money? The three examples, the three types. Three types are document of title to money, negotiable securities, and document of title to goods. As to document of title to money, it's understandable. You have that property, you can give it. It's commercially realizable. You can transfer it to somebody, and even without delivery or transfer, if you have that, it's a form of property. Negotiable securities, this is a bit complex. We will deal with that in upcoming chapters. And document of title to goods, which is at the heart of carriage of goods law, which is a bill of lading, which details everything about how the goods will be transferred and everything, where it will be coming from, where it will be going, what is going to be its quality. That gives you the right to even transfer goods when they are during the journey on the ship. Now, these three types, these are documentary intangibles, and this is pretty much everything that our commercial law is comprised of. The duty of the obliger to current holder of document the main duty, if there's a bill of lading issued against the carrier who's taking the goods, that duty is owed to the person who is holding the bill of lading, not the original person who created the bill of lading. So anyone who holds these documents, anyone who holds a note of 100 rupees, he's the person to whom the other person owes the duty. When you have 100 rupees, what is written on a note? That the state bank has it is a legal tender against the state bank, that they will give you anything in return for that 100 rupees value. So this is the main concept. It's understandable. The main thing is the possession. What this is establishing is obligations owed to the current holder. He who has possession has everything. As we know that law concerns is based favors 99% the person who is possessing the property. Pure intangibles. These are the rights which are not contained in a document. If you lose a document, doesn't matter. For example, debts. When you owe debts to a bank, your liability, your obligation is not based on that finance document. It is based on a legal relation that you have created based on a pure intangible. Contract rights, shares. So bill of lading is a document that gives you the title, whereas in a pure intangible, the document does not create any title. It is simply something that is of value, that can be transferred, that has all the four components of Ainsworth. So claims, the claims created by the pure intangibles are not created in a document of title. A contract is not a document of title, like a title deed of land. It's not a title document. It's a simple document that creates an intangible property. So these contract rights are transferable by some kind of assignment. In case of other document of titles that we have just gone through, these are the rights that are embedded in the document, that you can simply hand it over to somebody and he will have that. Whereas in a contract, if you are two parties in a contract, you have to make a formal assignment that this person is going to replace me. If you owe liability, if you have bought a car on loan from the bank, you have to assign your position as a debtor to some other person when you are transferring the car. Whereas car simply is a good that can be simply handed over to somebody and he can have that thing. So these are transferred by assignment or registration. Shares have to be transferred and then you have to be registered in the company's register of shares. Not actionable in conversion. This is something, the action of conversion is something that is advanced topic, but the main crux is that document of title like goods can be involved in action for conversion, because one good can be converted into another, and then you can bring a claim against that, whereas intangibles cannot be converted into anything. It just stays there. Whereas a document can be converted into some other document and then you can lay claim. It is something for advanced topic later. Now, beyond choses in possession and choses in action. So main thing is that now we're going to this is the important part, that property rights are not confined to individual assets. The dichotomy between choses in possession and choses in action is outdated, because you can have property in form of a fund. Fund is a collection of assets. Now this is an important example that will help you understand the nature of the very huge nature of property law. Collection of assets held by one person M, to manage on behalf of O, for instance. So what is fund? Fund has its own existence. O has claim against the fund, but not assets in the fund. So if you have created, let's suppose you have opened a mutual fund that you say you are M, you say that I will get 100 shares in this fund for the benefit of O. O cannot say that he has interest in one of those 100 or all of 100 shares. He only has interest in the overall fund created. Even if the fund has no item in it, let's suppose fund has not bought anything, O still has an interest in it and M still owns that fund. An example of fund can be a river. In a river, water comes, water goes out. Water comes, water goes out. The river stays there. It is a fund of waters that can come and change. It will not change its identity whether the water has, like Ravi. Ravi's right now, there's some little bit water left. Few days back, there was a lot of water in it, and before that, there was no water, but it was still Ravi. This is what fund is. So it is not composed of a single asset. When multiple assets come, it can create a new asset, a new property that creates legal rights, that has its own a commercial value, that can be sold, that can be profited from. The four criteria created by answer fits it, that it is definable, that somebody else can come into the place of O and say, no, I own that fund. Or O's legal heirs come tomorrow and they say that we are the heirs of O, and therefore this fund, the beneficial interest in the fund, belongs to us. M can be replaced by somebody. Fund is a very important and very interesting example. There's a separate article on it. I'm trying to find it, but this is how the advanced commercial and financial transactions takes place also in this fund framework, where you have funds of billions of dollars managed by few entities, corporate persons, for the benefit of hundreds and thousands of investors. And investors may not have any legal or even beneficial interest to any specific items in that fund, but they will have claim against that fund overall according to their percentage. And the person managing it has a legal title to all the assets, but does not have any beneficial interest in it. So there are many examples of new type of arrangements in which you can have different forms of property. The we all of us are right now, we are always hearing something about crypto assets. Now in the case of 2020, it has been realized by the courts that crypto assets is also a kind of property, but does not belong to the traditional choses in action and choses in possession. It is not a documentary title. It is not a pure documentary intangible, because when you own a crypto asset in the exchange, you don't own it against anyone. When you have a contract, you have a contract with somebody. When you have a note of 100 rupees, it is a contract between you and the state bank of Pakistan. But the new forms of digital assets, you just may own it, and if there's a market for it, you can sell it. Otherwise, there is nobody in between you and that property. So the point is, which is difficult to understand, is that there is a dispute between tangible, the difference between the categories of tangible intangible goods may not cover all types of property, including crypto assets. The court in a case said that crypto assets meet the four criteria given by Lord Wilberforce in Ainsworth. Singapore International Court also held this in the case of, in a 2019 case. The third category of personal property that has been posed is digital assets. We're not going to, this is not about what digital assets are. There will be a separate lecture on this, but there's something that differentiates them from choses in action and choses in possession. The tangible goods and intangible. And we have seen that in intangible, there are documentary intangibles where there is a document of title that gives you an interest in the intangible. And then there are pure intangibles that do not require any document of title, that exist purely because two parties have created that or as a legal fiction. But these digital assets, it is argued, do not conform to any of these property distinctions that we have read. The point that we need to understand most about is that property must have commercial value, and this can be explained with reference to three cases. Number one, the main point is that rights not enforceable by action, that is, if you cannot, if you do not have the standing to bring an action to claim a certain property or certain asset, or the rights not enforceable by action for certain property can still have commercial value, can still be capable of transfer, even if that power is limited, as we'll see. And the first case is receltic extraction. In this case, there was a waste management license. A management license was given personally to a company, and the terms of the license was that you cannot transfer it without the approval of the waste management authority. But the court held was that this had value and constituted property, this license. If this license can be transferred, let's suppose you get the approval, you can sell that license to somebody. It has commercial value, and therefore the implication was that this meets the concept of property under Insolvency Act 1986. It has value and constituted property under Section 436 Insolvency Act 1986, even if the transfer was limited by some certain way. So as you see, as I said in the earlier stages, that the concept of property keeps evolving as the question of transfer, as the question of insolvency, as disputes arise. Another interesting example of what can be property is this case, Swift versus Dairy Wise. In this case, one person had a registered EU milk quota. This quota gave you the right to produce certain quantity of milk without attracting EU tax. Therefore, if you had that quota, that means you can produce, let's suppose, 1,000 liters per day without having certain tax. Whereas other guy without the license will be worse off. So you can sell that quota. Let's suppose there is a right to sell that quota, to assign that quota. What happens? The underlying thing is that it has commercial value. Despite limits of how it can be held or conveyed, and the ultimate answer was that this was an asset under the Insolvency Act. This again was about insolvency, because one company certainly had gone into insolvency, and the liquidator said that this quota is also property and this can be sold and you can make money out of it. Similarly, unexhausted emission allowances also constitute property. Unwithdrawn salary, the Mia Saab, Mia Nawaz Sharif had unwithdrawn salary in his Dubai bank account under a comma is obviously property as well. So the main thing is the statute can limit. Now there is an example that certain licenses are specifically excluded from the definition of property, such as Section 36 Coal Industry Act. Property must have realizable value to be recognized. In Money Markets International versus London Stock Exchange, it was held that shares that had no value were not assets. They do not fall under the anti-deprivation principles of insolvency law. Now, what is this? I do not know about that. This is researchable. So mainly, whenever we have to think about commercial law, we are dealing with personal property. Firstly, understand the terminologies, because whenever you're going to read books, you will need to understand whenever this any mention of property, it can be land, it can be chattels, or these intangibles. But when you're talking about personal property, that means it is we're talking about goods, you're talking about contracts, debts, shares, bonds. You're not talking about land. And then you have this important distinction between choses in possession, which are physical goods, choses in action, which are intangibles. And then you have in intangibles, you have two main proper distinctions: documentary intangibles and pure intangibles. And this terminology was introduced by Roy Goode in 1982 or something, or in 1972, when he was drafting on consumer credit law. And within, and when we'll go through, Abdullah will give lecture on chapter 2 of Goode on commercial law. He will also talk about fungible goods, non-fungible goods, tangible, intangible distinctions. These are very, very important. And so crypto assets present us an opportunity to now think about the concept of crypto assets and its implications for different areas, and there's something that we can write about it in the future. So any questions about this? Mehak, any questions?
Not so far.
Anything that was confusing, that was not clear? Because it's an abstract area of commercial law.
Mm. No, I don't think so. I have any confusions.
Anything you guys would like to add to it, or anything that requires further understanding, further reading? Okay, so that's all for today. Are you guys available for a company law lecture, or do you want it to be done tomorrow? Nabil, you there? Okay, thank you very much. Thank you.